to do that.
I don't think when I can come in. I think I hold a different view. I may be wrong, but I hold a different view. By virtue of Section 292 of the Constitution, the CJN is different from an ordinary judge. It's different from let me say, any other court of any other justice in the Supreme Court or any other judge. If the CJ, so anything the CJ does, by virtue of section, my argument, I may be wrong, by virtue of Section 92 of the Constitution, you don't take him to the NJC. You take him to the Senate. It is the Senate that can now pass a resolution to remove him. So the idea of the CJ rescue opting out of any matter that comes before the NJC does not even arise. I hold the view that by virtue of Section 292 of the Constitution, whatever the CJ does, misconduct, infringement of the code of conduct as it relates to public officers, you take it before the Senate.
So it is wrong to go to CCT.
I don't think it is wrong because hold on. No, I'm not appropriate.
Should he appear?
I'm not appropriate. Look at what I'm saying. Look at what I'm saying. If before finding the man, before hanging the man, you need to take him through a process.
Where should the process start?
The process should start by taking him before the CCT.
But you
so
just said
he should appear today.
No, with the CCT now indicts him.
Should he appear before the CCT today?
I mean, he should appear. Why would he shouldn't appear?
No, but you just said now that he has whatever he does, he should go to the Senate for his removal.
Before you take
him,
I think before you take him to the Senate, you don't just take a man to the Senate without first of all taking him to a process where you find him guilty. And at that point, you don't have a material. You don't have something you can present before the Senate.
Where does it start?
Where does it start? That's the question.
Where does the process start?
From the office of the AG.
No. He has to where now? To where?
The AG to CCB.
No.
Where does it? How does it progress?
He has to go to the NJC. That is, he knows the current jurisprudence, the current law, which he has even cited.
The current jurisprudence is that to someone that judicial officers, not to the CJN. That's what I'm saying. Not to the CJN.
Okay, we'll come to Section 292.
No, look at Section 292.
We'll come to
the provision is clear.
Section 2921. But in context of what the SEN said about cases that were withdrawn as a result of the judgments between Nganjiwa and the Federal Republic of Nigeria.
Due process. Correct. Due process. But there's a different step or level that has to involve the CJN.
Yeah, go ahead.
Yeah. With respect to the CJN, you don't take him to NJC.
Finally, let me say this. If I want to go with his own argument, based upon Section 292, then the CJN ought not to appear before CCT. You take him straight to the Senate, based upon his argument. Not taking him now to CCT in order now to find a process of removal. No, you take him straight to the Senate and not to CCT, based upon his own argument now.
Well, Mr. Rukoro, help us out here. For you, where does the process begin?
It's very clear. The Chief Justice of Nigeria is the head of the third arm of government. The fundamental safeguard of the tripod on which the government of Nigeria stands is the concept of the separation of powers. It is known that the executive arm of government, which controls all the coercive powers of the state, is actually quite strong and could easily muzzle the other arms of government. That's why the framers of our Constitution, in their wisdom, tried to safeguard the other institutions so that they cannot be ruled over by a rogue executive. It can happen that you have an executive that wants a total accretion of powers to itself. And so these safeguards are there. Incidentally, there also are safeguards to make sure that the judiciary doesn't go rogue. It's very clear now that the Chief Justice of Nigeria is not just an arm, he's not just the head of one arm of government, he's also the judicial officer. And there is no exception in the Constitution, the disciplinary process and the powers of the NJC over every judicial officer. Clearly, the position of the law, and I think there's general agreement on this, you can see that almost all the senior lawyers take that position, is that the petition must first go to the National Judicial Council. As has been rightly said there, the CJN, being the person involved in this particular case, would not preside. There's a vice chairman of the council who acts in situations like this, and this NJC would look at this petition and determine, first of all, whether there is basic merit in it. If it is not, the NJC can throw it out. If the NJC comes to the conclusion that the Chief Justice of Nigeria, or the person, the judicial officer concerned, has breached his code of conduct for judicial officers and non-adherence, breaching the code of conduct for public officers is also a breach of conduct for a judicial officer, the NJC would make a recommendation to the president. The president would then decide which way to go. Now, in this particular case, my view is that he cannot be taken to the Code of Conduct Tribunal. And the reason is this. There are only two things that the Code of Conduct Tribunal can do. Can ban him from holding office for 10 years, or they can remove him from office. But by Section 292 of the Constitution, the Code of Conduct Tribunal cannot remove the Chief Justice of Nigeria. The powers of the Code of Conduct Tribunal are in a schedule to the Constitution, whereas the removal process, which is in Section 292, is in the body of the Constitution. Now, all students of constitutional interpretation know that the schedule is inferior to the main body of the Constitution. And so Section 292 would prevail over the fifth schedule. So if the NJC finds that there's a prima facie case, to make a recommendation to the president, who may or may not accept it, the president can say, all right, I've seen the infraction, but in my view, it's a triviality. We'll let it go. It's not worth damaging the image of the country for. Because what these proceedings are doing now is telling the whole world that we're a banana republic, that our Chief Justice is corrupt, is criminal, and all that and all that. And remember, this trial in the media, you can't take these things back. And some people would hear of the charges, they won't hear when the man is exonerated. So the president can decide that it's not worth sending to the Senate. But if he thinks that it's serious enough, then they would take this matter to the Senate. Now, there's a requirement for 2/3 majority of the Senate to remove Chief Justice, and there's a good reason. Look, he who is without sin, the Bible says, let him cast the first stone. There's no public officer that if you look at closely would not have committed one infraction of the other, sometimes unconsciously. In this particular case, the CJN readily said, oh yeah, I made a mistake. I forgot. And look, if you are to fill forms every 4 years, and then you are elevated from one position to another, and so on and so forth, it can get confusing. And that is why the law setting up the Code of Conduct Bureau and Tribunal makes it clear that you don't just jump into it. In fact, the first step you take is invite the public officer if you think there's a discrepancy in his assets,
Mr. Okoro,
and discuss
just pardon us.
If he owns up,
pardon me, we'll come back to you so you can take us through that process and what do we do moving forward. That's when we'll come back in a moment. Stay with us.